Hello everyone, welcome to Jury Search Academy. This is Sudipta, founder of Jury Search. Today we are going to talk about Article 15. In the last three videos, I have talked about Article 12, 13 and 14. If you haven't checked the videos, kindly go and check it. We have discussed about the important case laws, the most important objectives that are frequently asked in the exam, and also some very vital points to remember for your revision regarding those articles. So in this video, I'm going to talk about Article 15, the important questions, MCQs, important points, case laws, and the codes that you need to remember for Article 15 regarding your CLAT PG and ugc-netlaw law exam. So before starting the video, and do subscribe our channel and press the bell icon. So let's start the video. Article 15 is a directive. It directs the state not to discriminate any citizen under this five head: religion, race, sex, caste, and place of birth, or any one of them. Article 15 is a special application of the general principle embodied in Article 14. And Article 15 is available only to the citizens of India, whereas Article 14 is available all the persons. Article 15 too does not only prohibit state from making any discrimination, but also prohibits the private individuals from making any discrimination against any citizens on the grounds of race, sex, caste, religion, and place of birth. And there are certain matters to it as well, like access to shops, public entertainment, any public resort, or any place that has been fully or partially owned by the state, or any use of the public bathroom, tanks, wells under these places. The case is Yusuf Abdul Aziz versus State of Bombay. In this particular case, Section 497 of the Indian Penal Code was challenged. The validity of this particular section was challenged, and it was upheld that this particular section is an enabling provision under Article 15(3) to protect and to benefit the women, especially. So that's why this particular provision was then upheld. But after that Joseph Sign case, this section 497 has been struck down. In the case of Salil Wali vs. Union of India, the Supreme Court actually held that fixing 18 years as upper age limit for treating a person juvenile under Juvenile Justice Act is absolutely valid. And basically Supreme Court kept the judgment under Article 15 subclause 3 because it's an enabling provision for the benefit of the child, because fixing an age, actually by that we can determine the child in conflict with the law, and we can bring them back from where they are right now, the messy situation they are right now. Okay, so that's why fixation of the age is very important, and Supreme Court gave the judgment under Article 15(3). And also there are all internal conventions like CRC, Article 1 of the CRC, they talks about the fixation of the age, the importance of the fixation of the age. This particular case is one of the main reasons for the inclusion of Article 15(4) regarding the special provision for backward classes. Now this case is State of Madras vs. Champakam Thorai, and you might have heard this case name. This case is basically arises when State of Madras issued a government order regarding some reservation for the students in their engineering and medical colleges, and that particular government order was challenged because of the fact that that particular order was given, the reservation was done in respect of particular race, caste, and religion. Now the state defended by saying that they are promoting the DPSPs, they are doing it for the social justice. But the Supreme Court basically struck down this government order by saying it is against the Article 15. For that, the state came up with the first amendment under Article 15(4) by saying and enabling the provision, special provision for the backward class. Backward class hasn't been defined in any article under the Indian Constitution, but Article 340 specifically talks about the President may appoint a commission which can investigate under that particular article to get into the idea who is backward class and who is not, and then the President may specify that whether the particular class has been considered as backward class or not. This particular line was said by the Supreme Court in the case of M.R. Balaji vs. State of Mysore. Now, while mentioning the caste may be a relevant factor but cannot be the sole factor to determine the backward class, Supreme Court says there are other factors like poverty, occupation and other criteria we need to check before determining a particular class as a backward class. Now also Supreme Court said in this particular case that there cannot be more backward class than the backward class. This two different concepts, backward class and more backward class, and this particular court, like the caste may be the relevant factor but not the sole determining factor to determine the backward class, both are set aside by the Mandal Commission case that we're going to talk in the Article 16. First, let me tell you the three leading cases. The first is Mandal Commission case, the second case is TMFY Foundation case, and third case is P.A. Inamdar case. Now, these three cases basically talks about private educational institution. Yes, you heard me right. In these three cases, one ruling was there. That ruling was state cannot make any laws regarding the reservation in cases of privately run educational institutions. It means there cannot be any reservation or backward class reservation in privately run educational institution. But this particular ruling has been set aside by Article 15(5). Before getting into the most important amendment under Article 15, I have a question for you and you have to find the answer of that question. The question is, under which case the Supreme Court said that Article 15(5) was not violative of basic structure doctrine? Now you are going to mention in the comment box under which case the Supreme Court held that. Now getting into the amendment part. Now talking about the important amendments under Article 15. Now there are three very important amendments under Article 15. Now, the first amendment is itself the first amendment, where basically Article 15(4) was incorporated into the Constitution. Special provision for the educationally and socially backward class. The next amendment is 93rd Amendment, where the reservation for the socially and educationally backward class in privately run educational institution, that amendment was done in Article 15(5). That was done through 93rd Amendment. And the third important amendment that is done in 103rd Amendment, where the economically weaker section reservation, that is done in 15 subclause 6 amendment. I hope you like the video, give it a thumbs up. And in this video we have talked about the important questions, the important case laws that we need to remember, and also the important codes that we need to remember regarding Article 15. Now in the next class we are going to talk about the Article 16 and some important case laws, some important MCQs that we need to revise, that we need to go through for our CLAT PG and ugc-netlaw exam. Now if you haven't already known the fact, so please let me share with you that we are providing the most affordable and most comprehensive PSU and LLM program to all the aspirants. Kindly go and check it out. That's given in the description below. And also we are providing the ugc-netlaw courses and mock test. For that the link is also given below. So for today it's end. Next week we're going to meet again and we're going to talk about Article 16. Thank you. See you soon.